reports which have been rendered to the Ministry of Corporate Affairs. So at the outset, let me quickly deal with the cross-border insolvency law and then move to the other minor amendments as I think they will be. The thrust, of course, is the cross-border insolvency. At the outset, the current Insolvency and Bankruptcy Code does not have any special provisions in relation to cross-border insolvency. The code currently contemplates that if there is a bilateral agreement where there is an agreement in relation to the provisions of the Insolvency Code of India and a foreign country agrees to apply the Insolvency and Bankruptcy Code to their procedures when there is a Indian company in the foreign country which is undergoing insolvency or restructuring or some form of resolution. So it's a very, very limited space that was contemplated when the 2016 law was enacted. And there is not a single case where governments have agreed to adopt the procedure of the Insolvency and Bankruptcy Code in a foreign country. So that's really an empty letter in some sense. And there was a need to therefore look at how these procedures could be actually made easier. So the government fell back on the uncitral mode of model law of cross-border insolvency, which has been as a result of treaty among nations. And it sort of is adopted by 51 jurisdictions out of the total of 55 jurisdictions, and therefore has some applicability in relation to how cross-border insolvency could be tackled. And on the basis that it is a treaty to which India is to be a signatory or is a signatory, this would have a binding effect under the Constitution of India because our law contemplates that a government treaty between governments has to be enforced as if it were local law. So based on those principles, the Insolvency and Bankruptcy Committee or the Insolvency Law Committee made a report to the Ministry of Corporate Affairs way back in 2018, spelling out the kind of modifications that we would need in relation to the model code, because that is the way the process of adoption of the model code of cross-border insolvency has to be introduced. That report was submitted to the Ministry of Corporate Affairs, as I mentioned, and again then in November 2021, because of certain regulations which were introduced as a draft by the Cross-Border Insolvency Rules / Regulations Committee in its report of 2020, a whole framework through regulation was also proposed, and it was called Draft Part Z. This really had the how to actualize the implementation of cross-border insolvency, following upon the introduction of the model code in the IBC Act applicable in India. So the framework, therefore, of the Insolvency Law Committee report of 2018, which is supposed to be the precursor of the Act, Amendment Act, proceeded on the footing that there would be a recognition of foreign insolvency proceedings in which a foreign representative would be allowed, would be appointed and would be allowed to participate under the Indian code and could make its claim in relation to foreign debt, which may have been incurred by the Indian company, like if it is a branch and therefore not a legal entity established under foreign law and has assets and liabilities in a foreign jurisdiction. The purpose of this was basically to ensure that foreign assets which on the basis of which foreign lenders or foreign traders would have participated in the business of the company would have debts which they need to resolve, and the assets within that particular jurisdiction may not be adequate to deal with the insolvency, which is a foreign insolvency, not in the nature of a foreign code applying, but a foreign insolvency territorially, because an Indian company in the nature of a branch or a permanent establishment is in insolvent circumstances. Because it is in a foreign country, obviously it would be dealt by a court of competent jurisdiction or a tribunal of competent jurisdiction in the foreign country, where there would be a aggregation of the assets and a determination of the claims. And if if the law proposes reciprocity between India and the country where this situation has arisen, then there would be a dealing with of such assets for application to the debts. But the purpose of cross-border insolvency is to really ensure that all the assets of the
हमारे पास
company.
ऐसे इतना काम है, काम करने वाले कम हैं, इस तरह के लोग हमें बेवकूफ बनाएंगे यार, हम कैसे झेलेंगे इनको, समझा कर।
I'm sorry, Sandeep, there seems to be somebody talking on the line.
So it's been muted now. Yes.
Okay, okay. So sorry, I got interrupted. So what I was trying to say is that the the expectation is that if there is an insolvency which is ongoing, which is could be in the nature of a corporate insolvency resolution process, which is really focused on the revival of a company, or if it is the nature of an insolvency, then the pooling of assets both in India and globally would be for the greater benefit of all the creditors across the world. So that is the compelling principle in relation to cross-border insolvency. Today, it is permissible for a foreign lender or a foreign creditor to actually come into Indian proceedings for recovery of Indian debts or Indian amounts which have been unpaid in relation to any trade, like in the nature of supply of goods or in the nature of supply of services. So both financial creditors and financial operative creditors can today, even if they are foreign lenders or foreign operative creditors, can recourse Indian proceedings in relation to an Indian debt.
It depends.
What is now sought to be done is to extend this principle to foreign debt and foreign lending, which could be lending in the nature of money lent and advanced to a branch of an Indian company. There are some basic principles which would need to be considered in relation to cross-border insolvency as to where these proceedings or these kind of proceedings should actually be taken up. And there are legal principles which are universally known, and they are now getting embedded in the law. The concept of a natural territorial jurisdiction would be where the place of a registered office of the company or the permanent establishment of the company, that would be the natural place where a cross-border insolvency could be instituted. But what happens is that it is possible that a domestic company may not be the center of main interest. This is a term of art which is used in cross-border insolvency, where what is looked into by the relevant courts or relevant tribunal is whether the Indian jurisdiction is the place of main interest, in the sense that has the maximum business been done within its jurisdiction, is the maximum debt lying in the Indian jurisdiction, is the value and the numbers in relation to the indebtedness in India, has the business in proportion to the foreign business, is it greater or lesser? And in circumstances where it is discovered that the Indian proceedings are not at the center of main interest, the Indian tribunal cedes its jurisdiction to a foreign tribunal where there is a center of main interest. So effectively the jurisdiction can be altered by a process of application made to the tribunal to decide this particular question. It is also possible that the in the foreign jurisdiction, the foreign creditors could have approached the local court which has jurisdiction in relation to corporate insolvency. There could be an official liquidator which could be appointed by a foreign tribunal, but because the liquidation can only happen where the situs and the registration of the company is made, a foreign jurisdiction cannot really order winding up of an Indian company. Only an Indian tribunal can order the liquidation and realization of assets in the Indian jurisdiction. So how does the process work when there are foreign creditors and there are domestic creditors, and the legal entity which is under consideration is a single entity, and we're not talking here of group entities, or we're not talking of group insolvency, which is a different concept, where again there is a model law under preparation. So the two fundamental principles that I've just mentioned are, one is the ability of a foreign representative to be able to access the Indian tribunals and present the case on behalf of the foreign creditors and the foreign liquidator before the local Indian court. And the second one is the determination of the center of main interest. The third main important principle is that there would be a recognition of the foreign proceedings in the main proceeding. So if there are orders which have been passed by a foreign tribunal, which has jurisdiction in relation to insolvency matters, then those foreign orders would be reciprocally maintained in India, and the Indian tribunal or the Indian court would respect, on account of comity and on account of reciprocity, the orders passed in a foreign jurisdiction. And this is a principle which would be mutually observed between India and another treaty country of the UN model law on cross-border insolvency, and by virtue of the fact that we would accept the treaty by becoming a signatory to that. So the process under Indian law or even international laws is that as soon as a company is brought into liquidation or is brought into insolvency proceedings, there would be some amount of automatic relief which would be given for protection of the assets which come within that jurisdiction. This is based on the premise that creditors in various jurisdictions should not be duped by the assets being frittered away, and a protective order which sort of keeps the assets in control and regulates the business of the insolvent company in the sense that only specific permitted businesses could be undertaken for the proper and profitable liquidation of a company. The assets should not be used so that the creditor's assets are effectively denuded. So that kind of reciprocity is what will be brought into the amended law when the provisions of the cross-border insolvency would be incorporated in the Act, IBC Act. So these are the three main principles that are relevant, and it would mean that there would be dual proceedings, simultaneous proceedings, if there are is there a foreign court and a domestic court are both dealing with the questions of insolvency. This would require mutual hearing across territories at the same point of time. Therefore, it will be like a division bench almost in dealing with Indian assets, Indian liabilities, and the ability of a foreign creditor with a foreign asset like lying in a branch, which would be dealt with at the same time. The Indian creditors will get access to the foreign assets and share in the pool of foreign creditors based on their standing, whether they are secured creditors or unsecured creditors or operational creditors, and vice versa. a foreign creditor will also fall in the same categories. So the these are the principles which will be observed, and because the law of India is going to permit cross-border insolvency, the process of application of the funds, the process of sale of the properties for settling the dues of creditors would be that which is maintainable under the Indian Bankruptcy Code. That will become the governing law, except when there's a shift by virtue of the commie principles, in which case, because the main assets are outside the country, the process would be regulated by that particular court in that particular jurisdiction. But there would not be much of a deviance between what has been enacted in Indian law and the foreign law, because then the reciprocity principle would be seriously disturbed. I'm not going to go into the questions of the committee which made the cross-border insolvency rules and regulations. Suffice it to state that whatever I just mentioned in the context of the amendments which are expected, the rules are essentially to deal with those similar issues, because they are procedural in nature and they actually give teeth to the statutory law or the substantive law in procedure both in India and abroad. It is expected that the foreign procedure which is incorporated in foreign law, if it is a commie country in the sense that the proceedings have shifted to a foreign country, that procedure will apply. But if India is the center of main interest, then the Indian cross-border regulations would apply. They would extend even to misconduct by a foreign representative. The whole basis of the regulations will deal with the issue that both foreign creditors and creditors of Indian debt or Indian supplies of products or services would be dealt on a pari passu basis without preference and without, in any way discriminating against them. The Ministry of Corporate Affairs in 2021
So
has
if I,
also, sorry.
sorry to interrupt. We should also be keeping few minutes for any question and answers. Just be mindful of that.
Yeah,
That's it.
I am fine if people want to ask me the question right away, or if people want to address the questions at the end of all three of our presentations. I'm fine either way. You can take a sense of the house from Sandeep,
Right.
or
And
you can ask yourself, whichever way you want.
Misha,
we
why
can
don't you
even
go
have
and ask
a
a
question.
question? Misha, why don't you go and ask a question? Because sometimes that helps in breaking the ice.
Right. So I think in terms of the cross-border regime, sir has laid out the broad scheme, and there were a couple of other aspects as well in the proposed amendment, including the carriage of proceedings of the avoidance applications. So if you may just want to just broadly inform the House about that proposed change as well.
So under Indian IBC law, there are detailed provisions in relation to transactions which need to be avoided by either the resolution professional or by the liquidator. These types of transactions are transactions which have been fraudulent in nature, or extortionate in nature, or preferential in nature, in the sense that they have been undertaken to denude the company of its asset base so as to defraud the creditors from having a uh, larger asset base which could be applied to debt. So the law therefore naturally proceeds on the footing that if somebody has done any of these three kinds of actions or transactions, they would be unraveled with effect from a date, and that date is likely to be amended as part of the IBC. Currently, it is effectively the date of recognition of the application for commencing CIRP. But the amendment which is going to happen is that it will now relate to the date of filing of the application uh, for uh, for a commencement of the CIRP, so that it captures it captures things which could have happened post filing, but before the commencement of proceedings. That is one of the amendments which is contemplated. As Bisha correctly explained, that the fraud played in any jurisdiction is something which is antithetic sorry, is not valid in the context of all kinds of creditors, whether foreign creditors or domestic creditors, and therefore proceedings could be initiated in either jurisdiction if a fraud is discovered in either jurisdiction. And the avoidance principle, which is embedded in Indian law, would be similarly available in the foreign jurisdiction, or by virtue of an order in India which has been passed in relation to a wrong practice, as I explained, the three kinds of practice, then it could be reciprocally enforced also in a foreign jurisdiction. Either the center of main interest would pass these kind of orders, which is effectively unraveling uh, illegal transactions, or the local court could also pass such orders, which will be then enforced within the local jurisdiction. And if it has a cross-border effect, it will be also enforced in India.
Thank you, sir. I guess from the chat box, I don't have any other questions. And if anyone has question, they can put it on the chat box and I'll put it to the relevant speaker. With this, given the time, I would call upon our next speaker, Mr. John Handel. He's the National Practice Head for Competition Law at the firm. He has 40 years of competition law experience at Europe and India now. John, if I may just request you to take us through the proposed amendments in the competition law.
Well, thank you, Misha. And please carry on moderating as effectively as you have been up to now. This is called a rapid reaction seminar. So I have probably about 10, 15 minutes to try and take you through quite a complicated bill. The bill has been approved by the Union Cabinet and is scheduled to be introduced in the current monsoon session. It has not yet been published, and we are still not sure what the bill will contain, and indeed whether it will be taken up in the monsoon session. So I'm sorry, in a sense, what we're doing today may be a bit premature. But there have been a few anonymous hints, and it seems likely that much of what was in the 2020 draft bill, which was published in public comment, will be reflected in the new bill. Also, bear in mind the seminal work of the Competition Law Review Committee, which should inform any debate. So what is likely to be in the bill? If the 2020 draft is any indication, it promises to be very wide-ranging, covering a plethora of institutional, procedural, and substantive matters. After 13 years of operation, and in new and challenging economic and technological times, the Competition Act needs updating to make it more agile and fit for purpose. I'd like to focus on a few of these likely changes regarding enforcement, merger control, and institutional structure. I regret the need for a health warning. Please do not assume that these changes will in fact appear in the bill or after hopeful debate in the final act. All should be clear soon, but it may not be all so clear this evening. I apologize. First, in relation to enforcement, as regards anti-competitive agreements, the Act currently addresses horizontal and vertical agreements, though other agreements may fall within the Section 3 framework. The bill may provide that other agreements may be covered where shown to have an appreciable adverse effect on competition, following the approach taken for vertical agreements. There have been concerns that provisions on determining whether there is an AAEC, an appreciable adverse effect on competition, and on defining the relevant product and geographic market are too inflexible to cover modern conditions, including new age markets. It's possible that these may be addressed by allowing the CCI to specify additional factors by means of regulation. The opportunity may also be taken to introduce the test of supply-side substitutability in defining product markets. At present, only demand-side substitutability is expressly covered. Next, hub and spoke cartels, in essence, cases where actors at a given level of the vertical chain facilitate a cartel at another level of that chain, may now be expressly caught by the Competition Act. Non-competitors will thus be liable where they actively participate in the furtherance of an anti-competitive agreement between competitors. The intellectual property rights defence contained in Section 3 of the Act on Anti-Competitive Agreements has up to now been limited to specified Indian legislation. It may now be extended to cover any law in force relating to intellectual property rights, including non-Indian laws. It may also, as suggested in the 2020 draft bill, cover abuse of dominance cases, but we're not sure that will happen. A major innovation would likely be the introduction of a system of settlements and commitments, allowing for certain cases to be resolved without the need for the CCI to go to a final decision whether or not there has been a breach, and ultimately avoiding appeals and litigation. If it happens, this very important development, it will only apply to vertical and the new residual category of agreements and abuse of dominance cases. It would not apply to cartel cases. So in relation to cartels, we have a very efficient and quite effective cartel leniency regime that provides for lesser penalties. This may be amended to provide for the withdrawal of leniency applications. But also, following recent CCI practice, leniency plus may also be introduced, which will provide an incentive to applicants for leniency in relation to one cartel to disclose information regarding other cartels. As regards investigation procedures, rules on investigations by the Director General, which is the investigatory arm of the CCI, including dawn raids, are currently addressed with reference to the company's legislation. These rules may now be detailed in the Competition Act itself, which will make things a lot clearer. Finally, on enforcement, the bill may also contain provisions on transparency by the CCI in drafting and issuing regulations. The 2020 draft also contained specific provisions on the publishing of guidance by the CCI, generally on the provisions of the Act and rules and regulations, and specifically on the appropriate amount of any penalty for contraventions, which is an important outstanding area where guidance is needed. So these provisions may also be contained in the bill. Now, again, apologies for going through in a rapid way, but it is a rapid reaction seminar, so I hope I'm following the spirit of the occasion. Turning now to merger control. As matters stand, mergers and acquisitions qualify as combinations where specified asset turnover thresholds are met by the parties or their groups. I don't have time to specify these here. But such combinations, subject to certain exemptions, must be notified to the CCI and implemented only where approval has been given. Strategic high-value transactions, especially in digital markets, have up to now escaped the net. they may now become subject to merger review. Given the interest in looking at such transactions, I suspect that the threshold for deal value or whatever will be quite low, but we'll have to wait and see. The CCI's shifting stance on the issue of control, moving from the test of decisive influence to that of material influence, and bringing more cases within its scrutiny, is likely to be codified. In terms of timetable, the current overall 200-day review period is likely to be reduced to 150 days, and the initial review period to decide whether or not to go to investigation may also be reduced. There are a number of areas where it is likely that time will be trimmed in order to allow for a more efficient and speedier determination of cases. The Green Channel route, which provides for a deemed clearance on notification to the CCI of combinations where the parties have no horizontal overlap, vertical relationships, or complementary businesses, is expected now to have a legal basis in the Act. This mechanism has been in place for a while, but it needs to be given statutory footing. The CCI has up to now rigorously enforced the prohibition on gun jumping. The bill, we feel, is likely to dilute the standstill obligation in the case of open offers or acquisitions through a series of transactions on a regulated stock exchange. These are not suited to the current merger review mechanism. Instead, it is likely that the CCI will specify how such acquisitions have to be notified, and the shares or convertible securities are to be maintained. In addition, it's likely the acquirer will be unable to exercise rights over such shares or securities until CCI approval. Section 43A, which currently explicitly penalizes parties where they fail to notify, may be expanded to cover gun jumping, which it already covers in practice, and the submission of incorrect information to a Section 21 inquiry, where the CCI looks into a combination that has not been notified. And finally, for merger control, the maximum penalty for parties making a false statement or omitting to furnish information, material information, may be raised from 1 crore, which is about $127,000, to 5 crores, $634,000 approximately. This would be a significant hike and a further inducement to notifying parties to tell all when notifying transactions. Finally, a couple of words on CCI structure. Some changes may be expected in the structuring and operation of the CCI and the Director General. If these go ahead, expect some time and effort to implement and bed down. You should know that the 2020 draft bill envisaged a larger CCI of 6 whole-time members as a chairperson, the introduction of a governing board to carry out general superintendent's direction and management of the affairs of the CCI, and a refocus of the CCI itself on decision-making. There have been recent decisions in the media that single members may be able to make orders at the expense of collegiality and collective informed decision-making, but we don't know whether this will appear in the bill. The DG, who heads the investigative wing, is currently appointed by the central government. It was envisaged that the DG be appointed by the CCI itself. So, by way of a quick conclusion, we'll have to wait to see. I think that much of what I've said will come to pass, but don't bank on all or anything until the bill sees the light of day and we have been through the fine print. Thank you, and Monsieur, if I stayed roughly with my time, I'm happy to take questions.
Thanks, John. You did comply with the time limits. There's a question for you, John. The question is, how robust are the CCI confidentiality regimes for cross-border authorities to have faith in supporting them?
I'm sorry, I missed your question.
Right. So how robust are the CCI confidentiality regimes for cross-border authorities to have faith in supporting them?
Well, I'm not sure if confidentiality has been covered in the draft bill. There's been some recent changes to the confidentiality regime, which have been addressed separately by the CCI. I think the question relates to confidentiality in cross-border.
Right. So I think the expectation is that for overseas authorities to seek cooperation or support CCI, is there a confidentiality regime where the authorities abroad can cooperate with CCI in its investigation in case there is a cross-border element in the investigation?
Well, I mean, all I'd like to say this evening, I think, is that there are various agreements between different antitrust bodies in different member states, and their specific provisions are made in relation to treatment of confidentiality, which of course has to be respected when information is exchanged between these authorities. I'm not sure I can say much more than that. Certainly in the context of this bill, I don't think it will be covered in the bill.
Right. There's one more question, John, and the question is the nature of the proposed settlement provision prospective, or will it also apply to ongoing investigations?
I don't know the precise answer to that. I perceive that it might. I mean, essentially, commitments may be offered between the time that something is referred to the DG and the DG report arises, and then the settlement happens after DG report is made. I can't see why it shouldn't apply, but clearly it's going to have more value in relation to future cases. But I think it may well apply to current cases. But I'd have to double check and confirm on that once we see the bill.
Right. Thanks, John. Thank you for this. Unless the audience have any more questions, we'll move on to our last speaker for the day.
Thank you.
Thanks, John. So our last speaker for the evening is Mr. Jatin Aneja. He is the partner and national practice head for projects and project finance. Mr. Aneja would be covering the expectations and key features of the proposed bill relating to overhauling of the regime around SEZs in India. Jatin, if I may just request you to take over.
Hi, Misha. Thank you. Good evening, everyone. Caveat at the outset, the bill that I'm wanting to talk about is not in the public domain in terms of the actual text. So a lot of it is our understanding of it and what has been written about it in the public domain. So the government proposes to introduce the Development of Enterprise and Services Hub bill, which is largely a bill to subsume / overrule the whole special economic zones regime and provide for setting up of development hubs for overall promotion of industrial development, services development, exports, and overall economic development. Firstly, I just want to get into, what was the need for, or what was the problem, or why do we need this new law? So at the outset, there was a WTO's dispute settlement panel, which has ruled that India's export-related schemes, including the SEZ schemes, were not consistent with WTO rules, as they directly linked benefits to exports, and countries are not allowed to directly subsidize exports. Also, I think SEZ started losing their luster on account of introduction of minimum alternate tax and sunset clauses. And as you all know, there were 100% income exemption available for the first 5 years, then 50% for the next 5 years, and so forth on. So that's how the whole need for a new law comes into being. The bill which is proposed to be introduced is aimed, as I said, at setting up development hubs for promoting industrial development and it will overhaul the existing special economic zones and revive interest in SEZs and develop, a more inclusive economic hubs. These hubs are supposed to facilitate both export-oriented and domestic investment, and they would also allow people to supply into the domestic area, and people will be allowed to sell in the domestic market easily with duties only to be paid on the imports and raw materials instead of the final product, which is the presently in the SEZ regime. One of the key features that the bill proposes to do is, or the idea behind the bill is to use the idle infrastructure which is there in SEZs, and whenever things are not being used for exports, use that for the domestic production and promotion as well. So the hubs are supposed to promote manufacturing, trading, services, and trading is an important element because, till now, I think more impetus was there only on manufacturing and servicing, but trading is also sought to be seen and to do basically any and all activities which are in line with the current GST laws. The bill proposes that there will be a single online window portal for the grant of time-bound approvals for establishing. Much has to be seen on that. I have, in my time as a lawyer, come across a lot of single window clearances. I'm not sure how they pan out in actual practice, but good to know that there is a single window clearance. I hope it works, and that to an online portal. That's great, to be very frank. As I said, the focus is on broad-based economic growth. The idea is to promote employment and to have overall economic growth and development hubs rather than only SEZs for export purposes. It is expected that the states will play a greater role in these development heads. It's also expected that the current, so a lot of states have current industrial parks and for development of industries. It is expected that all of these, including the SEZs, will also come within the regime of the development hubs, and the states will play a vast role in developing of that, and it won't only be left to the center. On account of the new law, now there won't be any requirement to have a net foreign exchange positive requirement to be undertaken in 5 years as mandated in the SEZ laws, and we'll be allowed to sell in the domestic area more easily. There is an expectation that there would be some tax rebates, refunds, or financial subsidies in a manner similar to SEZ. My expectation is that there could be things in the nature of corporate tax or other benefits like we had for setting up of new industrial companies which get a lesser tax. So that's broadly what the expectation of the bill. Apologies for the fact of not being more specific because the devil is in the detail and and we haven't seen the actual text of the bill. So that's broadly the bill which is coming into being. I'm a bit conscious of the time because we have a 1 hour window and I think very less time is left. So if anybody has questions, happy to take that up. Over to you, Michelle.
Thanks, Jatin. I don't have any questions on the chat box, so anybody wants to raise the hand and ask the question or type it out for us, we're happy to answer. And in fact, a question either to any of our speakers here.
So Jatin, I have a question for you. This is Sandeep from USIBC. So we have seen that there are a number of this work from home notifications which are coming in from the different SEZs across the country. Now, many of them are actually creating a lot of confusion. Now, with the coming in of this new law, I mean, are there any changes which will come in? I mean, are they going to override the current work from home notifications which are coming in?
Yes, so the expectation would be that the moment a new law comes into being, it would overrule everything within the SEZ law and everything will get subsumed. And as a result, the notifications or rules under the SEZ law will also get overruled. And my expectation is, yes, that would be the case because, the whole work from home for SEZs is more in tune with, are you a special economic zone and therefore are you physically working there, or can you be allowed to work from home or not? Which is, because special economic zone is considered a special area which is for export orientation and you're not in the domestic zone to speak. The whole development hub will remove that whole concept of an export zone versus a domestic zone, and it's all development hub. And I would imagine that there would be hardly any restrictions on work from home in that space. It'll be more where are you supplying the services? If you're supplying the services or the goods, are you exporting them? Then the benefit will be available. If you are supplying it to the domestic area, then it'll get taxed in line with the GST laws. Misha, I think you're on mute. I can't hear you.
Sorry, we have one more question for you. Do we anticipate any penalties in case of non-compliances in the new regime?
See, I think the new regime is more supposed to be enabling rather than penalizing in its nature. And the expectation is that if you are doing export thing, you will get benefits in tune with that, because the whole SEZ regime is in the fact that you need to maintain exports, you need to have net exports in 5 years, you need to show that it's an export-oriented unit, you need to comply with a lot of laws, and domestic area supply is an exception, so to speak, to a special economic zone, whereas a development hub is not seeing the domestic supply as an exception. It is a norm, so to speak. So I would say that there will be incentives for exports. They may not be penalizing, as in there won't be a mechanism that if you don't do this much exports, then you will lose your license or you will be in violation of law. That is not expected. But again, it'll depend on the letter of the law.
Right, understood. Thanks. One more question for you. How do we see the benefits, incentives currently being accorded to SEZs going further, maintained but in a different form, or not incentivized?
I think the present incentives will get subsumed in terms of be applicable only to the export element of the development hub, and to that extent it will get subsumed. And for the supply into the domestic, it will be on parallel with any other supply in the domestic area. That's the expectation.
Right, understood. Anybody else has any question for any of the speakers? Happy to raise it.
I think we should also take the opportunity to just kind of inform everyone that the current monsoon session had a data protection bill, which was supposed to be introduced and passed, and it was there in the Parliamentary Committee, and it was much debated. But now it has been withdrawn, which is a major development, and it'll need to get rejigged and we'll bring it back. And I know a lot of companies, including financial institutions, including, everyone was was going to be affected by the new data protection bill. So that is an update which has happened, and that's happened as of yesterday. So I just thought I'll bring it up an update, and happy to send the firm, we're happy as a firm to send an update to everyone at USIBC on, what the nuances of that. But that bill is now off the table, and it's going to get totally reworked, and it's going to get introduced in its new avatar. I thought I'll mention that for everyone's benefit.
Jatin, I just wanted to check if you're following another bill, which is the Press and the Registration of Periodicals Bill 2022. There seems to be also some amount of interest among our membership around it. So if you can actually just, if you're aware of it, of course.
I am personally not, but happy to get into it and come back to you on it. But I'm personally not really following that. Kind of doesn't fall in my practice area domain.
Okay.
Sandeep, this is Suhan. I've sent a copy of the competition amendment bill, the draft that's introduced to Parliament. You can share it on the group. I have a copy. So I've just sent it to you on email. You can send it to everyone who is here on the call. That's the draft that's is introduced into Parliament earlier this afternoon.
Okay. Yeah, you're right. Probably it's going to be actually introduced on Monday. So
yeah,
probably
going to a standing committee. The Parliament's referring it to a standing committee. I don't think there's going to be a discussion. But the latest copy I've just sent you. And send it to everyone on the call.
Okay.
I appreciate that. Thank you.
So any other questions around this SEZ bill? Because we thought there would be a lot of discussion and questions around it. I'm a bit surprised that there is not any others.
I think that's the effect of being last in the line. So probably that's the reason.
Okay, but this was really a kind of wonderful discussion overall. It was a little bit dense. I mean, we intentionally didn't want any PowerPoints, etc., because given that none of these bills have been introduced in Parliament, we didn't want to leave a kind of a footprint around what we are trying to talk about this. But nevertheless, I think Misha and others, you have probably agreed that you'd probably give us a gist of what has been discussed on this particular call so that we can share it across to our members, because the information was pretty dense. And it's also helpful that we also have a draft copy of this competition amendment bill. We will share it to all our members and also across to the people who have joined on the call. And overall, I think I'll thank everyone for joining this call. This is wonderful. And I think while we expected that this to be a rapid reaction webinar, but unfortunately, this was not a reaction because these bills have not been introduced in Parliament yet, because given the way Parliament is functioning this particular session, it seems very difficult that any business is getting done. But nevertheless, thank you everyone for joining this evening, and especially to your speakers, Mr. Shardul Shroff, John Handel, and Jatin Aneja. Thank you very much for doing this for us. And we hope to continue this. And hopefully after the bills get introduced, we can probably again have a quick, rapid reactions again around all of them. And
That
thank
made
you,
it more
Misha.
useful. Thank you. Thank you.
And thank you, Misha. You have been wonderful. You have been wonderful as a moderator.
Thank you.
Thank
Thanks.
you, everyone.
Thanks.
Bye-bye.
Thank
Have
you.
a good
Bye-bye.
evening. Bye-bye.